The letter was sitting on my front porch when I got back from feeding the horses. A bright yellow envelope. Official looking. The kind that makes your stomach drop before you even open it. I set down my water bottle and picked it up. The return address read, Saddleback Ridge Homeowners Association, Compliance Division. Compliance Division. I didn't even know we had one of those. I tore it open. Inside was a single sheet of paper, printed on letterhead so clean and corporate it looked like it came from a law firm. Notice of violation. Property 4400 Crestline Road. Infraction, unpermitted agricultural structures. Penalty $150 in Towers Morn. 14 days. They'd been fining me for 14 days, without sending a single word. I read it twice. Then a third time, $150, 14 days. They'd been fining me for 14 days without sending a single word. I read it fret. Then an already $2,100, and a line at the bottom that said, continued non-compliance may result in lien placement on property. A lien. On my ranch. I looked up from the paper. The sun was going down behind the ridge. My horses were still moving around in the paddock. The barn I'd rebuilt with my own hands was standing right where it always stood, right where my grandfather built the first one 60 years ago. Nothing had changed on this property. Nothing except apparently someone had decided they owned a piece of it. I folded the letter and walked inside. I set it on the kitchen table next to my coffee mug and just stood there for a minute staring at it. Then my phone buzzed. Unknown number. I answered. Mr. Calloway. The voice was smooth. Polished, the kind of voice that was used to getting what it wanted. This is Gerald Marsh. I'm the president of the Saddleback Ridge HOA. I'm calling to make sure you received our compliance notice. I just read it, I said. Good. Then you understand the urgency. Those structures you have on your land, the barn, the equipment shed, the water tank installation, none of those were submitted for HOA architectural review. That's a clear violation of our CC&Rs. I didn't say anything for a second. Mr. Marsh, I said slowly, who told you I'm part of your HOA? There was a pause. Short. But I caught it. Every property in Crestline is governed by Saddleback Ridge, Mr. Calloway. That's not a question, that's a fact. His voice had shifted. Just slightly. The polish was still there, but underneath it was something else. Something that sounded a lot like a man who wasn't used to being questioned. I'd strongly suggest you come into compliance quickly, he continued. The fines don't stop accruing just because you disagree. He hung up before I could respond. I put the phone down on the table next to the letter. Then I walked to my filing cabinet and started looking for the deed to this land. My grandfather bought this land in 1961. My grandfather bought this land in 1961. He paid cash for it, every acre. He was a quiet man who didn't trust banks and didn't trust people who talked too much. He trusted the land, and he trusted paper. Signed, recorded, filed paper. That's the thing about men like him. They documented everything. The filing cabinet in my office is an old steel one. 4 drawers, dented on the left side from when we moved it in 20 years ago. I know exactly what's in every drawer because I organized it myself after my father passed and left the ranch to me. Top drawer, equipment warranties, veterinary records, insurance policies. Second drawer, tax records going back 15 years. Third drawer, water rights documents, grazing permits, utility easements. Bottom drawer, the original property deed, the survey maps, and everything connected to the land itself. I pulled open the bottom drawer. The deed was right where it always was, inside a manila folder, inside a clear plastic sleeve, exactly the way my father taught me to keep it. I carried it to the kitchen table and sat down. 4400 Crestline Road, 2114 Corn Acres. Recorded with the county in 1961. Transferred to my father in 1987. Transferred to me 11 years ago. I read through it carefully. Every line. Every legal description, every boundary marker reference. There was no mention of any homeowners association, no CC&Rs, no easements granted to any governing body. No recorded covenant of any kind tying this land to any organization called Saddleback Ridge. I sat back in my chair. The thing is, I already knew this ranch sat on land that predated the surrounding subdivision by decades. Saddleback Ridge, the actual housing development, was built in the early 2000s. Cookie-cutter houses on quarter-acre lots carved out of land that used to be open range. My ranch wasn't part of that development. It never was. But Gerald Marsh didn't know what I knew. And more importantly, he didn't know what I had. I took photos of the deed with my phone. Then I drove into town the next morning and made 3 sets of copies at the print shop. 1 set went back in the filing cabinet. 1 set went in a fireproof box in my bedroom closet. 1 set went in a fireproof box in my bedroom closet. 1 set went into a folder I labeled simply HOA. When I got home, I looked up Saddleback Ridge HOA online. Their website was slick. Professional. They had a full board of directors listed, architectural review committees, a community newsletter archive. They had a page called Governed Properties with a map. My ranch was on that map, not at the edge of it, not as a footnote. Right in the middle, highlighted, listed as a non-compliant property. I stared at that screen for a long time. Someone had made a decision about my land. They put it on a map, assigned it to their jurisdiction, and started sending fines without ever checking whether they had the legal authority to do any of it. That told me something important about Gerald Marsh. He was either sloppy or arrogant. In my experience, those two things usually go together. The second letter arrived 4 days later. This one wasn't yellow. It was white. Heavier stock. And it came certified mail, which meant I had to sign for it at the post office. The woman behind the counter handed it to me with a look that said she'd seen these before. I signed the slip, tucked the envelope under my arm, and waited until I got back to my truck to open it. Final notice of noncompliance. Accrued balance, $2,850. Saddleback Ridge HOA hereby notifies property owner that failure to respond within 10 business days will result in referral to association legal counsel for lien proceedings. $2,850 in 18 days. And now they were threatening a lawyer. I folded the letter, put it in the folder, drove home. That evening I called my neighbor Dale. He runs a cattle operation about 2 miles down Crestline Road. His family has been out here almost as long as mine. We're not close friends exactly, but we're the kind of neighbors who look out for each other without making a big deal of it. You get anything from an HOA lately? I asked him. Long pause. Got a letter about 3 weeks ago, he said. Told them to lose my number. They fine you? Tried to. I ignored it. You hear from them again? Not yet. Another pause. You thinking this is going somewhere bad? I think it might, I said. Dale wasn't worried the way I was. He was further from the subdivision boundary. His property was less visible. Mine sat right at the edge of where the old ranch land met the new development. My barn was visible from the Saddleback Ridge entrance road. My water tank was visible from the main walking trail their HOA maintained. I was the easy target, the visible one. That's the thing about people like Gerald Marsh. They don't go after the hardest fight first. They go after the one that looks the most exposed. The following Tuesday, I drove past the Saddleback Ridge entrance. Slow. Just looking. There was a sign posted near the gate. New. Freshly installed. It read, Saddleback Ridge HOA Community, Stand-Forceman Zone. All properties subject to CC&R compliance review. I pulled over and took a photo of it. Then I noticed something else. A silver SUV parked about 50 yards down the road from my entrance gate. Tinted windows. Engine off. I watched it for a moment. Nobody got out. I drove in. Went about my business for the next couple of hours. Fed the horses. Checked the water lines. Repaired a section of fencing on the north pasture. When I drove back out that evening, the silver SUV was gone. But there was a new notice tucked into my gate. A printed form with a checkbox grid on it. Handwritten at the top, property inspection conducted. Multiple violations observed. Photographic evidence collected. They'd been on my property. Without permission. without notice, without any legal right. I stood at my gate holding that form, and for the first time since this started, I felt something shift inside me. Not anger exactly, more like clarity. I didn't sleep well that night. Not because I was scared, but because my mind wouldn't stop working through the details. Someone had walked onto my property, past my gate, onto land my family had owned for over 60 years, and they'd done it like it was routine, like it was their right. They'd taken photographs of my barn, my equipment shed, my water tank installation, all of it documented and labeled as violations. And the worst part was, they probably thought that was completely fine. That's what kept me up. Not the trespassing itself, but the confidence behind it. The casual, unquestioned certainty that they had authority over this land. I got up at 5 in the morning and made coffee. I sat at the kitchen table with the deed, the 2 letters, the inspection form, and my phone showing that screenshot of their website map. I laid them all out in a row and looked at them together. Here's what I knew so far. My land predated the Saddleback Ridge development by 40 years. My deed had no HOA covenant attached to it, no CC&Rs, no recorded restrictions. And yet they had placed my property inside their jurisdiction on an official map, sent me escalating financial penalties, and now conducted an unauthorized inspection. What I didn't know yet was how they thought they could legally justify any of it. That question mattered, because the answer would tell me exactly how strong my position was. I called a real estate attorney that morning, not to hire him yet, just to ask one question. His name was Robert Acosta. I'd used him years earlier for a water rights dispute. Straightforward guy. Didn't waste words. I explained the situation in about 4 minutes. Told him about the deed, the letters, the website map, the unauthorized inspection. He was quiet for a moment. "Do you have a copy of their CC&R document?" he asked. "No," I said. "I didn't even know they existed until 10 days ago." "Get it," he said. "CC&Rs have to be recorded with the county to be legally enforceable against any property. If your deed has no reference to them and their CC&Rs have no recorded annexation of your parcel, they have zero authority over you. Zero. How do I get their CC&Rs? County Recorder's Office. Public record. Everything recorded is searchable by address or parcel number." I wrote that down. "One more thing," Acosta said. "That inspection. If they came past a closed gate without your permission, that's criminal trespass in this state. Document everything. Timestamp it. Don't confront them. Just collect." I thanked him and hung up. I drove to the county recorder's office that afternoon. The clerk was a patient woman named Margaret who clearly helped people navigate this system 1,000 times. I gave her my parcel number. She typed it in. She looked at her screen. Then she looked at me. "There are no CC&Rs recorded against this parcel," she said. "Nothing from any homeowners association. Nothing at all." She said it simply, professionally, but I heard it like a door swinging wide open. I asked Margaret to print that for me. She did. 1 page, official county header, my parcel number at the top, and a clean, simple notation that read, "No covenanters, conditions, or restrictions recorded against this parcel." I folded it carefully and put it in my folder. On the drive home, I stopped at a hardware store. I bought 2 trail cameras, the kind hunters use, small, weatherproof, motion-activated. Good resolution day and night. I installed them that evening before dark. One faced my entrance gate from inside the property, angled to capture anyone approaching from the road. The other covered the south side of the barn, where the inspection form had described the most violations. I tested both. Clear images, timestamp visible in the corner of every frame. Then I did one more thing. I would back to the Saddleback Ridge HOA website and click through every page. Board meeting minutes, architectural review decisions, fine schedules, community announcements. On the 3rd page of their archived newsletters, I found something interesting. A notice from 2 years ago. It read, "The board is pleased to announce the expansion of our governed community boundaries to include adjacent ranch parcels along Crestline Road in accordance with our master development CC&Rs. Pleased to announce," like they'd voted on it at a Tuesday evening meeting and that made it real. Like putting a line on a website map was the same thing as a legally recorded annexation. I read it 3 more times. there was no mention of notifying affected property owners, no mention of county recording, no mention of any legal process whatsoever, just a newsletter announcement buried in a PDF archive that most people would never find. This wasn't an accident. This was a pattern. Someone on that board had decided to expand their authority onto land they had no legal claim to. And they'd done it quietly, without paperwork, without process, banking on the fact that most people wouldn't know the difference between an HOA announcement and an actual legally binding document. Most people would get a letter with a fine attached and assume it must be legitimate. They'd panic. They'd comply. They'd pay. And maybe some of them had. That thought sat heavy with me for a while. I thought about Dale down the road. Had he paid anything before he started ignoring them? I didn't know. I thought about whoever else might be on that expanded boundary map. Smaller landowners, older folks, people without filing cabinets full of organized deeds and easy access to a real estate attorney. People who just saw a fine and assumed someone had the authority to issue it. The next morning, Gerald Marsh called again. "Mr. Calloway, your 10-day window is almost up. I want to give you the opportunity to resolve this before it goes to our legal team." His voice was the same as the first call, smooth, patient. The tone of a man offering mercy. "I appreciate that, Mr. Marsh," I said. My voice was calm, completely calm. "I've been doing some research of my own." "Research won't change your obligations under our CC&Rs," he said. "That's an interesting position," I said. "I'll be in touch." I hung up first this time. 3 days later, a car pulled up to my gate. Not the silver SUV this time, a newer model. Black, clean. The kind of car that said the person driving it wanted you to know they were serious. A man got out. Mid-50s. Pressed khakis. A polo shirt with a small logo on the chest I couldn't read from a distance. He stood at my gate and looked at the property like he was inventorying it. My trail camera caught all of it. I watched from the porch. I didn't go down immediately. I let him stand there for a full minute before I walked down the gravel path toward the gate. He smiled when he saw me coming. The kind of smile that's really just a power move. "Mr. Calloway, I'm Dennis Farwell. I'm on the Architectural Review Committee for Saddleback Ridge." He extended his hand through the gate bars. I shook it. "Gerald asked me to come out personally," he said. "We'd like to resolve this cooperatively. Nobody wants lawyers involved." "That's good to hear," I said. He pulled out a folded document, held it up so I could see it. "This is a compliance agreement. You bring the barn and equipment shed into our architectural standards, remove the visible water tank installation, and we'll waive 60% of the accrued fines. You'd only owe around $1,200. He said $1,200 like he was doing me a favor. I looked at the document without taking it. "What are your architectural standards for agricultural structures?" I asked. He blinked, just slightly, like the question wasn't what he expected. "They're outlined in our CC&Rs. I can have a copy sent to you." "I'd like that," I said. "Can you also send me the recorded document number from the county for your CC&Rs?" Another blink. "That information is available through our HOA management office," he said carefully. "Sure," I said. "But since CC&Rs have to be recorded with the county to be enforceable, the county document number should be easy to pull up. I just want to make sure I'm looking at the right filing." The smile didn't disappear, but it tightened. "I'm not the person to answer legal questions, Mr. Calloway. I'm here to help you reach compliance." "I understand," I said. "I'll wait for that document number." He folded the compliance agreement and put it back in his pocket. We shook hands again. He got in his black car and drove away. I went back inside and wrote down the time, the date, his name, and everything he'd said. Word for word, as close as I could remember it. Then I pulled up my trail camera footage and saved a copy of his entire visit to an external hard drive. That evening I called Acosta again, gave him the full update. The newsletter annexation notice, the compliance agreement offer, Farwell's visit, the fact that they couldn't produce a county document number. He listened without interrupting. "They're bluffing," he said when I finished. "They have no recorded authority over your parcel. Every fine they've issued is legally void. And that inspection, I want you to write up a formal trespass notice and we'll send it certified mail to Marsh directly." "Will that stop them?" I asked. "No," he said. But it'll matter later. I was starting to understand what later meant. Acosta drafted the trespass notice that week. It was 2 pages, clean legal language. It named Gerald Marsh specifically, referenced the unauthorized inspection by date, cited the relevant state statutes on criminal trespass, and formally notified him that any entry onto my property without explicit written permission would result in immediate law enforcement contact. I sent it certified mail. Return receipt requested. Gerald Marsh signed for it on a Thursday morning. I know because the green return card came back to me 4 days later. His signature was small and cramped, the kind of handwriting that pressed too hard on the pen. I added it to the folder. By this point the folder had gotten thick. The original deed, the county recorder's certification, both HOA letters, the inspection form, the trail camera screenshots, my written record of every conversation, Acosta's notes, and now the certified trespass notice with the signed return receipt. 14 documents, all organized, all dated. I didn't tell Marsh any of this. I didn't respond to the HOA at all. I just kept collecting. That's the part people don't understand about situations like this. The temptation is to fight back immediately, to write an angry letter, to show up at their board meeting and make a scene, to let them know you know. But that burns your advantage. Every day they believed they were in control was another day they kept showing me exactly who they were, and they kept showing me a lot. The next thing happened on a Wednesday afternoon. I was out on the north pasture checking a section of water line when I heard a vehicle on my property. Not at the gate. Inside the gate. I walked back toward the barn. A white pickup truck was parked near the equipment shed. 2 men I didn't recognize were walking around it with clipboards pointing at things, writing notes. I stood still for a moment and watched them. My trail camera was already recording. Then I walked over. "Can I help you?" I said. They both turned. The older one recovered faster. "We're with the HOA compliance team," he said, "conducting a follow-up inspection." "Did anyone let you through my gate?" I asked. He looked at the other man, then back at me. "The gate was open," he said. It wasn't. I knew it wasn't because I'd closed and latched it myself that morning, but I didn't argue that point. "Not yet. I need you both to leave my property immediately," I said. "You do not have permission to be here. You were formally notified of that in writing last week." The older man held up a hand. "Mr. Calloway, we're just doing our job. If you cooperate now, it'll go a lot better for." "I'm going to call the sheriff," I said. "You have about 2 minutes to be off this property before I do." They left. Quickly. I called the sheriff anyway. A deputy came out within the hour. I showed him the trespass notice, the signed return receipt, and the trail camera footage of both men entering and moving around my property. He took a report, wrote down both men's names from the HOA compliance documentation they'd left behind in their hurry. Before he left, he looked at me with a straightforward expression. "You've got good documentation," he said. "Keep it up." I already was. The sheriff's report was filed on a Friday. By Monday, Gerald Marsh knew about it. I know because he called me that afternoon. The smoothness in his voice was still there but thinner now, like a coat of paint that was starting to crack at the edges. "Mr. Calloway, I understand there was an incident Friday involving our compliance team." "There was," I said. "I want to assure you that wasn't authorized by me personally. Those men misunderstood their instructions." I let that sit for a second. "Gerald," I said. It was the first time I'd used his first name. "You sent a certified trespass notice back to my attorney. You sent a certified trespass notice acknowledgement back to my attorney. Your signature, your name. That notice covered every agent acting on behalf of your HOA. Not just you personally." Silence. First real silence I'd gotten from him. "I think," he said finally, "that we may have gotten off on the wrong foot here." "I think," I said, "that you should talk to a lawyer." I hung up. That evening I called Acosta and told him about the conversation. He was quiet for a moment. "They're starting to feel it," he said. 2 trespass incidents on record, a sheriff's report, and they still have no legal footing on your parcel. If they keep pushing, they're not just losing. They're building a harassment case against themselves." "Is that useful to us?" I asked. "Very," he said. In this state, knowingly issuing fraudulent fines and placing illegal liens constitutes civil fraud. If we can show a pattern of conduct, especially after formal notice, damages start becoming real. I hadn't thought about damages yet. I'd been focused on stopping them. How do we make sure the pattern is airtight? I asked. Keep doing what you're doing, he said. Document everything. Don't confront them publicly. Don't threaten them. Just let them keep moving and keep recording it. I did exactly that. The fines kept coming. A new letter arrived the following week. The accrued balance was now listed at $4,350. There was a new line at the bottom I hadn't seen before. Notice of intent to place property lien within 30 days pending continued non-compliance. A lien threat, in writing. I photographed it and sent a copy to Acosta immediately. He called back within the hour. His voice had a different quality to it now. Focused. That lien threat is the line, he said. They have zero recorded authority over your parcel. Threatening a lien based on fraudulent CC&R claims is a separate cause of action entirely. That's not just a property dispute anymore. What does that mean practically? I asked. It means we start building the complaint. We go to court not just to stop them, but to make them pay for what they've already done. I sat with that for a moment. Outside my kitchen window, the horses were moving through the evening light. The barn my grandfather built the bones of was throwing a long shadow across the paddock. My grandfather never backed down from anyone who tried to take something that wasn't theirs. To take something that wasn't theirs to take. I wasn't planning to either. Build the complaint, I said. Acosta filed the complaint on a Tuesday morning. He called me right after to walk me through it. We were suing Saddleback Ridge HOA, Gerald Marsh personally, and the 2 compliance officers who trespassed on my property. 4 causes of action. Fraudulent misrepresentation of authority. Civil trespass. Harassment. And intentional infliction of financial harm through the issuance of legally void fines. Total damages sought $180,000. That number included the void fines, attorney fees, and compensatory damages for the documented pattern of harassment and trespass. Acosta had attached everything. The deed. The county recorder's certification. Both trespass incidents with trail camera evidence, the sheriff's report, every letter, every phone call log, the newsletter annexation notice, the signed return receipt, all 14 documents, plus the trail camera footage saved to disk. How long before they respond? I asked. They have 30 days, he said. My guess is they'll try to settle quietly within 2 weeks. And if they don't, then we go to court and they lose publicly. Either outcome was fine with me. What I didn't expect was what happened 3 days after the complaint was filed. Dale called me. You file something against the HOA? He asked. I did, I said. Long pause. I got a letter from them 6 months ago, he said slowly. Fined me $900 for my irrigation equipment being visible from the road. I just paid it. Figured it wasn't worth fighting. I closed my eyes for a second. Dale, I said, you need to call Acosta. You think I can get that back? I think you never should have had to pay it in the first place. He called Acosta that same afternoon. And then 2 days after that, a woman named Carol Hendricks called me directly. She'd heard through the rural property owner grapevine that someone on Crestline Road was fighting the HOA. She was 71 years old, widowed. She'd inherited her late husband's 12-acre property 3 years ago. The HOA had been fining her for 18 months. She'd paid over $6,000 total because she thought she had to. Because nobody told her she didn't. $6,000. She cried a little when she told me. Not dramatically. Just the quiet kind of crying that comes from realizing you've been carrying something heavy that you never needed to carry. I kept thinking if I just paid, they'd leave me alone, she said. But they never did. They won't leave you alone because paying confirmed their authority, I said as gently as I could. But you didn't know. Nobody told you. I gave her Acosta's number. Within 10 days of the complaint being filed, Acosta had 4 clients from Crestline Road, Dale, Carol, a retired couple named the Garcias who'd paid $2,200, and me, combined fraudulent fines collected from non-HOA properties, over $11,000. Acosta amended the complaint. The new damages figure was $340,000. Gerald Marsh had built his little empire one frightened landowner at a time. He just hadn't counted on one of us actually checking the paperwork. The HOA's response to the amended complaint arrived on a Friday afternoon. Acosta called me as soon as he read it. They hired a lawyer, he said, someone named Philip Greer. He's filed a motion to dismiss on the grounds that all properties along Crestline Road fall within the original master development boundary. Even though there's nothing recorded at the county? I asked. That's exactly their argument, Acosta said. They're claiming the master development CC&Rs from 2003 automatically govern all adjacent parcels within a defined geographic boundary. They attached a copy of the original development filing. Does that hold up? Not even slightly, he said. CC&Rs don't work like zoning laws. They don't automatically attach to land just because it's nearby. They have to be recorded against each specific parcel, and their 2003 filing makes zero mention of your parcel number or Dales or Carroll's. They're essentially arguing that geography equals jurisdiction, which it doesn't. Which it absolutely does not, Acosta said. But here's what's interesting. Their 2003 filing actually helps us, because it clearly defines the original governed parcels by specific lot numbers, and none of our clients' parcels are on that list. So their own founding document proves our case. I almost laughed. They had handed us the weapon and we were going to use it. What's next? I asked. We respond to the motion to dismiss. I'll have that ready within the week. Then we request a hearing date. How's Gerald taking all this? His lawyer sent a separate letter, Acosta said, asking if our clients would consider a private settlement conference before the hearing. There it was. The first real crack. What do you recommend? I asked. Attend the conference, he said. Let them show their hand. But we don't settle cheap. Not after what Carroll paid. Not after what Dale paid. Not after 2 trespass incidents and a lien threat. The settlement conference was scheduled for the following Thursday. A neutral location. A conference room at a title company downtown. I drove there with Acosta. We arrived 5 minutes early. Gerald Marsh was already in the room when we walked in. He was sitting across the long table with Philip Greer beside him and Dennis Farwell 1 seat down. It was the first time I'd seen Marsh in person. He was smaller than I'd imagined. Not physically small, exactly. But the room didn't bend around him the way his voice on the phone had suggested it would. He was just a man in a blazer sitting in a chair, looking at the table. He looked up when I walked in. I met his eyes and held them for a moment. Then I sat down. Greer opened with an offer. They would dismiss all outstanding fines for our 4 clients. 0 balance, clean slate. In exchange for our clients signing a release of all claims. I watched Acosta's face. He didn't move a muscle. That's not close, Acosta's face. He didn't move a muscle. That's not close, Acosta said quietly. Our clients are owed restitution for every dollar already collected. Full remark, plus damages. Marsh leaned forward slightly. We're prepared to return 50% of collected amounts, Greer said. 100%, Acosta said. Plus documented attorney fees, plus a formal written acknowledgement that these properties are outside HOA jurisdiction, recorded with the county. Marsh's jaw tightened. The meeting ended without a deal. The hearing date was set for 6 weeks out. In those 6 weeks, 3 more things happened that changed the shape of everything. The first was a phone call from a journalist. Her name was Sandra Okafor. She wrote for the regional newspaper that covered the county and surrounding rural areas. Someone had tipped her off about the lawsuit. She pulled the public court filing, read the complaint, and called Acosta's office. Acosta told me and asked if I was comfortable talking to her. I thought about it for exactly 1 day. Then I called her back. We talked for about 40 minutes. I walked her through the whole thing. The letters. The fines. The trespass incidents. The county recorder's certification showing no CC&Rs on my parcel. Carroll's $6,000. Dale's $900, the newsletter annexation announcement that had no legal backing. Sandra was a careful journalist. She didn't editorialize. She asked precise questions and wrote down my answers without commentary. Before she hung up, she said, I'm going to reach out to the HOA board for comment. Standard process. I wanted you to know. That's fine, I said. The article ran 8 days later. Front page of the county section. Headline: Rural landowners sue HOA over fines collected from non-member properties. It was factual, measured, but the facts were damning enough on their own. Sandra had obtained a statement from Gerald Marsh through Greer. The statement said the HOA was confident in its legal position and that the matter was before the court. That was it. That was all they gave her. The article also included a quote from Carol Hendricks. 3 sentences. She talked about receiving the fines after her husband passed, about paying because she was afraid of losing the property, about finding out she never owed a single dollar. My phone rang for 2 days after that article ran. The second thing that happened was that a 5th property owner contacted Acosta, then a 6th, both from Crestline Road, both with documented payments to the HOA over the past 3 years. Acosta amended the complaint again. Total fraudulent fines now documented and collected from non-HOA properties, just over $19,000. The third thing was the most significant. Acosta received a document request response from the HOA as part of the pre-hearing discovery process. Among the documents produced was a series of internal board meeting minutes from 2021. In those minutes was a recorded vote. The board had voted 4-1 to expand their governed boundary to include the Crestline Road Ranch parcels. The motion was made by Gerald Marsh, seconded by Dennis Farwell. The dissenting vote came from a board member named Patricia Holloway. Her recorded objection read, "I want it noted that we have not obtained legal counsel on whether this expansion is enforceable, and I do not believe we should be issuing fines against these properties until we do." 4-1. They'd overruled her. They had known there was a legal question. They'd been warned internally. And they'd gone ahead anyway. Acosta called me the evening he found that document. His voice was the quietest I'd ever heard it. "They knew," he said. "I know," I said. "This isn't negligence anymore," he said. "This is deliberate." The hearing was on a Wednesday morning. I drove there alone. Acosta had told me to dress plainly. Nothing that looked expensive or performative. Just clean and straightforward. I wore the same boots I wore to feed the horses every morning. Dark jeans, a button shirt. I looked like what I was. A rancher who'd driven in from Crestline Road to tell the truth in a courtroom. The HOA side arrived with Greer and 2 associates. Gerald Marsh sat at their table in a charcoal suit. Dennis Farwell was beside him. They had a stack of binders. The judge was a woman named Honorable Claire Sutton. She had the manner of someone who had seen every version of every argument and wasn't impressed by volume or confidence. She moved through procedural matters quickly and without ceremony. Acosta presented our case methodically. He started with the deed, displayed it on the courtroom screen, walked through the legal description, pointed to the recording date, 1961. Then he displayed the county recorder's certification. No CC&Rs recorded against the parcel. Ever. Then the HOA's own 2003 founding document. Showed the specific lot numbers listed as governed properties, showed that none of our clients' parcel numbers appeared anywhere in it. Then the 2021 board meeting minutes, the 4-1 vote. Patricia Holloway's recorded objection. Read it aloud in full. The courtroom was very quiet when he finished that part. Then he displayed the fine letters, the lien threat, the trail camera footage stills of the unauthorized inspections, the sheriff's report, the certified trespass notice, and the signed return receipt. Finally, he displayed a simple spreadsheet. 6 property owners. Total fraudulent fines collected, $19,400. He sat down. Greer stood and argued that the master development boundary established geographic jurisdiction regardless of individual parcel recordings. He cited 3 cases. Judge Sutton asked him one question. "Counsel, in any of the cases you cited, did the court find that CC&R obligations attached to a parcel that was never individually recorded under those CC&Rs?" Greer paused, opened one of his binders, flipped through it. The cases address boundary jurisdiction in a general yes or no, counsel. Another pause. "No, Your Honor." She made a note. She didn't rule from the bench immediately. She said she would issue a written ruling within 14 days. Standard process. We walked out of the courtroom into a bright morning. Acosta said he felt good. I didn't say anything for a moment. I stood on the courthouse steps and looked out at the street. Ordinary Wednesday morning. People walking. Traffic moving. Somewhere across town, Gerald Marsh was probably sitting in his car telling himself it wasn't over yet. He was wrong. And somewhere on Crestline Road, Carol Hendricks was probably doing whatever a 71-year-old woman does on a Wednesday morning. Living her life on her land. Quietly. Without being afraid of a yellow envelope in her mailbox. That mattered more to me than anything else about this day. I drove home, fed the horses, checked the water lines, repaired a section of fencing on the south pasture that had been pulling loose for a week. 14 days felt like a long time. It passed faster than I expected. The ruling arrived on a Thursday afternoon. Acosta called me before I'd even seen it. His voice had that quiet, focused quality again. The one that meant something real had happened. "We won," he said. "All 4 causes of action. Complete ruling in our favor." I sat down at the kitchen table. "Read me the important parts," I said. He did. Judge Sutton had ruled that Saddleback Ridge HOA held no recorded legal authority over any of the 6 plaintiff properties. All fines issued against those properties were declared legally void from the date of first issuance. The HOA was ordered to return every dollar collected from all 6 plaintiffs within 30 days. Full restitution. $19,400. Then the part that mattered most. The court found the board had proceeded with fine issuance despite documented internal awareness of unresolved legal questions regarding their jurisdictional authority. Patricia Holloway's recorded objection had been entered into evidence, and the judge had referenced it directly in her ruling. The word she used was willful. Willful disregard of legal boundaries. Willful collection of funds without legal authority. Because of that finding, the HOA was also ordered to pay our combined attorney fees. And Judge Sutton referred the matter to the County District Attorney's Office for review of potential criminal fraud charges against the board members who had voted in favor of the expansion. Gerald Marsh, Dennis Farwell, and 2 other board members whose names I hadn't even known until the discovery documents came in. Referred to the district attorney. I let that land for a moment. "What about the recorded acknowledgement?" I asked. "That their jurisdiction doesn't cover our properties?" "Ordered," Acosta said. "They have 60 days to file a formal recorded document with the county recorder's office acknowledging the boundary. It'll be public record permanently. Permanent. Public. Recorded. Anyone who searched my parcel number in the future would find that document. Any title company. Any buyer. Any neighbor who got a suspicious letter in a yellow envelope and started asking questions." I thanked Acosta and hung up. I sat at the kitchen table for a while without moving. Outside the window, the horses were doing what horses do in the late afternoon. Moving slowly. Unhurried. The barn was throwing its long shadow across the paddock, the way it always did at this hour. Nothing about the ranch looked different. But something had been settled here. Something that went deeper than a court ruling or a dollar amount. My grandfather had bought this land because he believed in the permanence of honest ownership. That if you paid for something fairly and kept your paperwork straight and treated your land with respect, nobody could take it from you. He was right. He just couldn't have known that 60 years later someone would try anyway. Someone did try, and they had failed. Completely. I called Carol Hendricks. She answered on the second ring. "We won," I said. She was quiet for a moment. "All of it?" she asked. "All of it," I said. "You'll get every dollar back." She didn't cry this time. She just said, "Thank you." Simple, quiet, real. The district attorney's review took 11 weeks. I didn't follow it closely. I had a ranch to run, fencing to repair, a water line on the east pasture that had been giving me trouble since spring, horses to feed every morning at the same time regardless of what was happening in a courthouse downtown. But Acosta kept me informed. The DA's office had subpoenaed the HOA's complete financial records. Every fine issued, every dollar collected, every board vote, every internal communication going back 5 years. What they found went further than Crestline Road. The expansion onto our properties wasn't the first time the board had pushed their boundaries without legal authority. There were 2 other incidents from earlier years, smaller, quieter, properties that had been absorbed into their fine system without ever formally being recorded under their CC&Rs. Most of those owners had simply paid and moved on without ever questioning it. The total amount collected from non-governed properties across all incidents came to just under $47,000. $47,000. Collected from people who didn't know they didn't have to pay. Collected by a board that knew they might not have the authority to collect it and went ahead anyway. Year after year, one frightened property owner at a time, Gerald Marsh was charged with 4 counts of civil fraud and 2 counts of intentional financial misrepresentation. Dennis Farwell received 2 counts. The other 2 board members who had voted for the Crestline expansion received 1 count each. Patricia Holloway, the one dissenting vote, was not charged. Her recorded objection had protected her completely. I thought about that a lot. One person in that room had said, had said we need legal counsel before we do this. Had said I don't believe we should be issuing fines until we're sure. 4 people had overruled her. And now those 4 people were facing criminal charges while she was walking free. It's a simple lesson. But people forget it constantly. The pressure of a room full of confident voices can make the cautious voice feel like the wrong one. It never is. Marsh's attorney negotiated a plea agreement. He avoided jail time but received 3 years of supervised probation, a permanent bar from serving on any HOA board or property management organization in the state, and a personal financial judgment requiring him to contribute to the restitution fund. His HOA presidency was over. The board was dissolved by court order. A court-appointed administrator took over to manage the legitimate Saddleback Ridge properties through a transition period. Dennis Farwell resigned from every community organization he'd been part of before the charges were even formally filed. I heard through Dale that he'd put his house in the subdivision up for sale within a month of the ruling. I didn't feel satisfaction about any of that specifically. What I felt was something quieter, more like the feeling after a long piece of work is finally finished. The fence is mended. The water line is running clean. Everything is where it should be. The land was always mine. Now everyone knew it. Spring came early that year. The grass on the north pasture came in thick and green. The horses moved through it in the mornings like they owned every inch of it. Which they did. Which we did. Dale came by one afternoon in late April, parked his truck by the barn and leaned against the fence the way neighbors do when they don't need a reason to visit. We talked about water rights, about the price of hay, about whether the county was going to resurface Crestline Road before summer. Normal things, ordinary things. After a while he looked out at the pasture and said, "You know what I keep thinking about?" "What?" I said. "That $900 I paid them, I just wrote the check, didn't even question it." "Most people wouldn't," I said. "You did," he said. "I thought about that, about why I had when others hadn't. Partly it was the filing cabinet, the organized paperwork, the deed in the clear plastic sleeve exactly where my father had taught me to keep it. Partly it was knowing enough to make one phone call to one attorney before doing anything else. But partly it was something my father had told me when he transferred this land to me. We were sitting at the same kitchen table. He pushed the deed across to me and put his hand flat on top of it for a moment before letting go. "People will try to take what's yours," he said. "Not always with guns. Sometimes just with paper and confidence. Learn the difference between real authority and performed authority. Real authority and performed authority." Gerald Marsh had performed authority beautifully. The letterhead. The certified mail. The compliance officers with clipboards. The attorney in the settlement conference with his stack of binders. All of it designed to look so official that questioning it felt unreasonable. But performance isn't the same as legal standing. And confidence isn't the same as being right. Sandra Okafor wrote a follow-up article after the criminal charges were filed. She called me again, asked if I had anything to add beyond what the court documents showed. I thought for a moment. "Just one thing," I said. "If you get a letter that claims authority over your property, the first thing you do is go to the county recorder's office. Not a lawyer yet. Not a fight. Just the recorder's office. Public record. Free to access. It'll tell you in about 10 minutes whether that authority is real or not." She printed that. Word for word, almost. I got more calls after that article. People from 3 other counties. Similar situations. Different HOAs. Same basic pattern. Official-looking letters. Escalating fines. Quiet compliance from people who didn't know they had options. I gave them all the same answer. County Recorder's Office, parcel number. Public record, 10 minutes. That's all it takes to find out if someone's authority over your land is real or if it's just paper and confidence dressed up to look the same. Most people never think to check. Now maybe a few more will. A week after Sandra's second article ran, something interesting started happening. Not loud, not dramatic. Quiet, the kind of quiet shift you only notice if you've been paying attention from the beginning. Letters stopped. Not just for me. For everyone. Carol called me first. "I didn't get anything this week," she said. "No envelope. No notice. Nothing." "Good," I said. "That's how it's supposed to be." Dale noticed it too. The Garcias did. Even one of the newer property owners, someone who had just recently been added to Acosta's contact list, said the same thing. The pressure was gone. Just like that. Because once authority gets exposed publicly, it stops working privately. That's the part most people miss. Gerald Marsh didn't lose power the day the court ruled against him. He lost it the moment people realized they could question him. Everything after that was just paperwork catching up to reality. About 3 weeks later, I drove into town for feed supplies and ran into Margaret, the same clerk from the county recorder's office. She recognized me. "You're the ranch owner from Crestline, right?" she asked. "That's me." She smiled a little. "We've had a lot more people coming in lately, asking about their parcels, checking for CC&Rs. I nodded. "That's a good thing." "It is," she said. "Most people never look. They just assume." That word again. Assume. That's what this whole situation had been built on. Not law. Not documentation. Assumption. I picked up my supplies and headed back to the ranch. That afternoon, I pulled open the bottom drawer of my filing cabinet again. Same drawer. Same folder. Same clear plastic sleeve holding the original deed. But now there was something new added to it. A certified copy of the court-ordered boundary acknowledgement. Filed. Recorded. Permanent. It was only 2 pages long, but it carried more weight than every letter the HOA had ever sent combined. Because this one didn't rely on performance. It relied on fact. I slid it into the folder and closed the drawer. For the first time since this whole thing started, everything felt finished. Not quiet in the sense of nothing happening. Quiet in the sense of nothing happening and quiet in the sense of nothing needing to happen anymore. A month later, Sandra's final article ran. This one was different. Less about the conflict, more about the outcome. She wrote about the court ruling, the criminal charges, the restitution, but she also focused on something else. The pattern. How easy it had been. How a group of confident people with letterhead and a website had managed to convince others they had authority they never legally possessed, and how long it had gone unchallenged. She included one line from the judge's ruling that stood out more than anything else. Authority over property is not assumed by proximity, but established by record. That line stuck with me. Because it summed up everything, not just legally, but practically. In life, too. A few days after that article, I got one last unexpected call. It was Patricia Holloway, the one board member who had voted no. Her voice was calm, careful. "I wasn't sure if I should call," she said, "but I wanted to say something." I listened. "I argued against that expansion," she said. "Not because I knew for certain it was illegal, but because I knew we hadn't done the work to prove it was legal." "That mattered," I said. "It didn't feel like it at the time," she admitted. "I got outvoted. Dismissed. Told I was overthinking it. You weren't." She was quiet for a moment. "I'm glad you fought it," she said. "Not just for yourself, for everyone." "Someone had to check the paperwork," I said. She gave a small laugh. "That's usually all it takes." After we hung up, I sat on the porch for a while. The sun was starting to drop behind the ridge again, same way it had the day that first yellow envelope showed up. Full circle, but this time there was no tension attached to it. No unanswered questions, just land, quiet, exactly as it should be. The horses were moving along the fence line slow and steady. The barn stood where it always had. Nothing had changed, except now there was no one left pretending they had a claim to any of it. And that's the part that matters most, because in the end, this was never really about fines, or letters, or even the court case. It was about something simpler, knowing what's yours. and knowing how to prove it. Most people think power comes from titles, positions, or official-looking documents. But real power, it comes from understanding the difference between something that looks legitimate and something that actually is. Gerald Marsh had one. I had the other. And in the long run, only one of those holds up. If there's one thing I'd pass on to anyone listening to this, it's this. Don't panic when you get a letter. Don't assume someone has authority just because they say they do. And don't fight blindly. Check first. County records, parcel numbers, public filings. 10 minutes of real information can save you thousands of dollars and months of stress. Because once you know the truth, the rest becomes simple. And sometimes, simple is all you need to win.